heard about this press conference yesterday, and I decided to watch it live. And quite frankly, I felt extremely sad for the Chief Justice. Because what she succeeded in doing was to invite the press, which put the cameras on her, and then she declared that she's completely unfit to be Chief Justice of Ghana. That's what happened yesterday. You understand? First and foremost, her conduct is prejudicial and contemptuous of the process that she's part of. And I would have expected the Chief Justice to know better than what was exhibited yesterday. If she was sitting in court as a judge of the Supreme Court, as Chief Justice, whatever, as a justice, and somebody made statements which prejudge the outcome of the proceedings, what would have been her attitude? We have to be clear that there are two types of contempts. Contempt in facie cura and contempt ex facie cura. The most important ingredient is actions or comments likely to prejudice the outcome of the matter which is under consideration. It is contempt in facie cura when the comments are made in the presence of the court. Comments or actions are in the presence of the court. And it is contempt ex facie cura when it happens outside the view of the court. And what she did yesterday clearly amounts to prejudice, an attempt to prejudice the outcome of the court, of the proceedings of this inquisition, as some lawyers have described it. Now, for me, one of the most important points that she makes at this press conference has to do with the choice of venue for hearing the case. And you would wonder why that is the most important point for me. Judges, even in the lower courts, are human beings. All judges are human beings. They come with all kinds of biases and prejudice. But the expectation is that once they become judges, they will strive to overcome those prejudices that are inherent in their history, are inherent in the relationship they have formed, and so on. They must be able to rise above those prejudices. And indeed, when they are not able to rise above those prejudices, they are required by common sense and even the interpretation of the law to recuse themselves. Okay. Now, what did the suspended Chief Justice do yesterday? She came and said, this process is taking place at a Edu Lodge. Something happened at a Edu Lodge more than 40 years ago, which is related to my uncle. And because of that, I feel traumatized. I'm unable to make balanced judgments. I feel intimidated. I see ghosts, I see kakai when Edu Lodge is mentioned. Master, clearly, what she's saying is that she's not been able to rise above that prejudice which is inherent in her relationship with Major Aqua. That prejudice which is inherent in her family history and so on. Is that not worrying? I'm very worried about it. You understand? And all of us do know that that event she referred to has to do with the PNDC, the Provisional National Defense Council, over which Jerry Rawlings was chairman. So if she carries such a prejudice, if she's traumatized by that event, doesn't that suggest that she cannot be fair to anybody directly or remotely related to the PNDC.
Yeah.
What a statement to come from her.
Yeah.
So, based on her own statement, what was the case before her for determination? And the plaintiff's name by accident is Amatekwe. What will she do? Just think about it. Based on what she said yesterday at the press conference. Now there's a case before her, and the plaintiff or respondent or defendant is called Amatekwe, who was executed for the assassination of her uncle. Based on her own statement, what would be her attitude? I mean, this is the gravamen of what she said yesterday. The prejudice is inherent. She cannot rise above it. She's steeped in that prejudice. Her whole life is about the murder of Medo Aqua. It influences her. It gives her jitters and so on. Clearly, the statement she made yesterday is that she's unqualified to be Chief Justice because she cannot rise above her prejudice. She cannot rise above her prejudice, which is inherent in her family history and so on. And I was very deeply troubled by her own statement about herself. You understand? Very deeply troubled about that. Now, as Chief Justice, it is also clear that she must be very conversant with the law. She must know the law. Okay? And the law is made up of the hardcore letter of the law. Hardcore letter of the law. What the law says. The letter of the law. And also history. There are two components. The law in motion, that is its history. What judgments were arrived before, what contestations took place in the court and so on, all of that add to the interpretation of the law, and then the text of the law itself too. So I'm surprised that the Chief Justice's press conference clearly does not show that she's aware that the Supreme Court had made 3 determinations on some of the issues that she raises. And one of the issues she raises has to do with in-camera sitting of this committee. Indeed, Kwame, 3 Supreme Court decisions have been made before her case was referred to the Justice Praman Committee. And in the first case, there's a case of Justice Derry versus Tiger Eye. There's also the case of Ajay Chum versus Attorney General. And there is the case of the Ghana Bar Association versus the Attorney General. In all of these 3 cases, the Supreme Court decided that Article 146 proceedings ought to be in camera. Our Chief Justice does not know this. So if our Chief Justice does not know this, how competent can she be as a Chief Justice? She's not aware. She doesn't know that there have been 3 determinations. The such processes ought to be in camera. What? The Chief Justice doesn't know. Shocking. Let's put that aside. The Chief Justice is complaining that her husband was not allowed into the city. She said that her husband was not allowed into the city, so she's angry. So there's a conspiracy against her. This one, Master, you don't have to be a lawyer. You don't have to be a judge. You just have to be somebody who understands English small, not plenty, small. How can a proceeding be in camera and spouses are invited to sit in? Somebody must explain that to her. I think that I understand it, but she needs explanation. So when I heard that yesterday, I was completely taken aback. So this madam, this woman was Chief Justice of Ghana. How did she become Chief Justice of Ghana? Amazing, unbelievable. Can you believe that she was Chief Justice of Ghana? And she doesn't know that on 3 occasions, the Supreme Court, over which she presided on many occasions, had made a clear determination on this matter. And she wants her husband to come and sit in the process, in the proceedings. What will the husband do for her? The husband's presence. So, if the Chief Justice is telling us that she loses her balance when the husband is not around, and she is saying it, or I'm not saying it, that when the husband is not around, she becomes jittery, she loses her balance, she can't think properly, and so on. Okay, agreed. So when there are major constitutional cases which will determine the destiny of this country, and she's sitting in the Supreme Court, would we take her husband to sit by her and hold her hand for her to be firm and clear? I mean, unbelievable. The Chief Justice is certainly clearly telling us that she's not competent. Because if you have a judge who needs her husband or her wife's presence in court in order to give her vim and stability, then we're in trouble. If I lie, please tell me if I lie. Because that's an argument that when my husband is not around, oh my goodness, I can't do nothing. I start shaking and so on. So in all the cases that she presided over, was her husband in court? All the cases, I think we should check. Because if the husband was not in court, hey, then she did something to the law. Why are you laughing? Because she needs her husband. The husband must be by her to give her stability. You know, when the husband is not there, she's traumatized. So when she's sitting in the Supreme Court and making decisions and her husband is not there, she's traumatized. And she will use that trauma to give you a judgment. Why are you people laughing? No, I'm very serious.
No, it's a good analysis.
No, I am very serious.
No.
Some people's cases.
This one, it is.
You are presiding over people's destiny. You are presiding over people's destiny. You have the power. You actually, Uncle, you actually have the power to order that people should be killed. When you sit as Chief Justice and you sit in the Supreme Court, you have the power. You play God. You can actually play God. Yeah. Decide who should be killed and who should not be killed. And such a person tells us that in the absence of her husband, she goes gagas. What? Can you believe this? That when the husband is not there, and she has so much power. Wow. Incredible. I mean, I simply cannot believe it. But it gets worse. It gets worse. Master, it gets worse. This is Chief Justice of the Republic of Ghana. And Master, Ghana has had some of the best judges in the history of jurisprudence in Africa. And we can mention them. Prominent justice, Olenu, mention them, Akufo-Addo, and so on. The position she occupies has been occupied by giants in law, and so on. And that is how we should judge our justices of the Supreme Court, especially the chief amongst them. I'm a lay person. I didn't go to law school. I don't have any law qualification, Master. But I know, just from reading the Constitution, you don't have to be a lawyer to understand this, that when it comes to the enforcement of fundamental human rights, original jurisdiction is vested in the High Court and not the Supreme Court. Me, I know that. Our Chief Justice doesn't know that. Hey! Can you believe? So she actually goes to the Supreme Court to invoke the original jurisdiction of the Supreme Court to protect her fundamental human rights. She didn't know. Her colleagues at the Supreme Court had to tell her that, oh, Madam, as for this one, we beg you. That is not the case. The Constitution doesn't say that. And she's still insisting on sitting there as the Chief Justice. She doesn't know the law. What? Chief Justice Tokornor, she doesn't know the law. Unbelievable. Then, in her press conference, she says something else which is completely shocking. And it should be shocking for us. That the committee did not allow one of the petitioners, I think he's called Daniel Ofori, to testify. Wow. Master, you remember, you have to remember the election petition.
Yeah.
You remember?
Yeah. Big one there.
You remember the decision of the Supreme Court?
Big one.
The Supreme Court decided in our face, and in fact, that proceeding was televised. The Supreme Court decided that they cannot even force Jim Mensah to testify. You understand? They said they would not even allow her to testify. She's free to testify or not to testify. Yeah. And that was a case in which she was the presiding officer for that election. She was. That was a case in which she was the electoral chairperson of the Electoral Commission and so on. The Supreme Court decided that, no, madam, if you don't want to testify, it's okay. But our learned Chief Justice, and she's more than learned, her Lordship, the Chief Justice, doesn't know that. Her Lordship, the Chief Justice, says that the committee should have forced Daniel Ofori to testify. Unbelievable. Then another case which just kills me completely. Justice Tokornor holds a press conference and she says that I have not been given a copy of the petition. I am not sure what kind of petition the committee is dealing with and so on. But you see, she made a request to President John Dramani Mahama to give her 7 days to respond to those petitions. President John Dramani Mahama gave her 10 days, 3 more days, to respond to the petitions. And she did indeed respond to the petitions. True or false?
Exactly.
Okay. So, how could she have responded to petitions that she didn't know, the contents of which she didn't know? How could she have responded to those petitions? Then this matter comes up and she says, oh, yes, I've responded to the petitions, which means that she has the petitions, okay? I've responded to the petitions. But I am not sure that the petitions I responded to are the petitions which were given to the committee. Oh, madam, please. Master, it is not possible, and I'm saying this, it is not possible for the committee to have a set of petitions which are different from the petitions that she responded to. You know what? Because the inquisitorial process, okay, ultimately, what will lead to the determination of the case, the petition against her, is not the petition. It is the evidence which will be adduced, and the rebuttal of the evidence or the confirmation of the evidence. That is what ultimately will lead to decisions being made. I hope you understand that. Okay. So, if the petition she responded to accuses her of constitutional violation, and the petition before the committee accuses her of theft, it becomes so obvious.
Yeah.
Because the evidence which will be left will be evidence on theft and not constitutional violation.
Yes.
So it becomes so obvious. You don't need ChatGTP or whatever, to understand this common thing. Even those of us who are not lawyers, we understand. But unfortunately, she doesn't understand. She thinks that it is possible to have a set of petitions, sent to the president, and the president somehow will send another set of petitions to the committee. I mean, what an insult to the president. Can you imagine that this woman, this Chief Justice actually believes that she's dealing with a president who can be so dishonest as to give her a set of petitions to answer and send a different set of petitions to the committee? I mean, I can't believe it. She is demanding fairness, but she cannot even be fair to the president. She's actually calling the president a crook.
Yeah.
She's calling the president a crook. On what basis? No basis. She's calling the integrity of the president into question. She's actually calling the integrity, even by extension, of the whole Council of State into question. Without a basis. She's calling the integrity of a committee, constitutional committee, chaired by her colleague. Justice Foma is her colleague. In fact, when they sit on the Supreme Court, she's only primus inter pares. That is the rule, primus inter pares. So Justice Foma is her colleague. And she's calling Justice Foma's integrity into question without a basis. I can't believe it. But Kwame, it gets worse. One of the judges sitting on this committee served on the Supreme Court with her. And she has, on more than one occasion, empaneled him to deal with very, very serious cases. So when she was empaneling that judge, what did she think of that judge? When she was empaneling that judge, what did she think of that judge?
I mean, you were the Chief Justice.
Unbelievable. Completely unbelievable. I can't understand it. What is this? And then she makes another argument. I wish I had a copy of the Constitution with me. That one of the petitioners, which appears to be an organization, doesn't exist. That's the argument too. Says the petitioner doesn't exist. And why she thinks that the petitioner doesn't exist, apparently is because she's gone to the Registrar General and found that it is not registered as an organization. Whoa. Ankaranda. If you read the 1992 Constitution, if you read the portions on freedom of association, it does not require registration as authentication of existence. Yes, if you are registering a company to do business and so on, that's fine. But the four of us sitting on this table, can decide to act together as citizens without registering. And there is no law against that. When you read the provisions of 1992 Constitution, freedom of association. So if the four of us agree that tomorrow morning we hold a press conference on how to cook banana, nothing can stop our acting together as a group by any name, for as long as the four of us agree to act in that manner. Indeed, the only restraining thing, and even that is inferior to the constitutional provision, is the public order law. Because the public order law requires of us, if we want to act together, in public manifestations to notify the police, to give them notice and so on. But even that law is inferior to the provisions of the Constitution. And I've argued that the public order law needs to be challenged and repealed because it's unconstitutional. Because the Constitution grants unfettered right to citizens to protest, to demonstrate, to hold processions and so on. The public order law introduces fetters to that right. So I insist that it can be challenged. I don't have the means to challenge it, but I insist that it can be challenged. So that is the only fetter to citizens acting together and so on. So I don't know how the Chief Justice read the Constitution. I want to be very, very kind to her. But it is possible. It is possible that when she was reading the Constitution, the husband was not by her. Yes, because when the husband leaves her side, the confusion that she encounters is huge. So maybe Tim is right. That when the Chief Justice was reading the constitutional provisions and the freedom of association and so on, the husband perhaps may have,
gone out or something.
Gone out to some friends to chill small.
Because he's racing. If the husband were there, I don't think we would have put that in the petition.
By the way, was the husband present at the press conference? I didn't see the husband. I don't know the husband.
Yeah, I don't know that.
But maybe the husband was not present at the press conference. That may also explain some of the things that happened there. Come here, finish my submission.
Oh, I was enjoying